the more I read the dissenting judge that backs Najib's acquittal, the more I read his ruling, I follow his narrative, but something is amiss. Now, he argues that Najib was not given a fair trial because he was effectively unrepresented, okay? Because the court refused to give an adjournment to his new set of lawyers. This is notwithstanding that the one responsible to be changing lawyers at the 11th hour is Najib, but the court, this judge says that it is because the court should have given an adjournment, and then the court should not have prevented Hisham Pontek from discharging himself. And by forcing Hisham Pontek to be there, a grave injustice has happened to Najib. He was forced to actually be represented by an unwilling lawyer, and and that is because he was not given time, and therefore it negates even having a trial in the first place. Now, it did not occur to him perhaps that time was given to Najib, and whatever injustice that was inflicted on Najib is actually self-inflicted. Nobody forced Najib to change lawyers. Nobody forced Najib to change narratives. Nobody forced Najib to follow any particular narrative or defense strategy. Everything is owned by Najib. It is not the wrongdoing of the court or the prosecution. Najib, from the time he was charged at the High Court level, he has had his line of defense there and then, and his lawyers brought it all the way. He could have just continued with Shafi, but he decided to be creative. He decided to change lawyers. He decided to improve on his defense strategy, so he thought. But by doing so, he presumed that the court must facilitate, must aid, must add into that. That would not be, if court were to do that, then court would not be impartial. Court would actually be favoring the defense. Court cannot do that. Court given the time, court given 5 judges to preside and to hear the defense, and everything was good and fair. But this judge contends that it is unfair. Anyway, that is his opinion, that is his decision. He doesn't subscribe to the fact that Najib is the author of his own misfortune. Okay, Najib screwed up his own defense. Bukan orang screw up for him. He treats the lawyers and Najib not as one team. He treats that the lawyer is like an independent team, not as per Najib's team, and therefore Najib is paying the price due to the fault of his lawyers. It's like separate entities. So therefore, the court to him was not fair to Najib, because the court allowed the incompetence and the unwillingness of his lawyers to inflict a great injustice on Najib. This is a very warped kind of thinking, warped kind of logic, because he fails to understand that the legal counsel are chosen by Najib. Who represent him at any one time is chosen by Najib, and the accused owns the strategy of his own defense. This is a matter of law. Somehow this Chief Justice, who actually hate the bench, could not understand, or do not understand, or pretend not to understand. This is a very bizarre situation, and I believe that something is amiss. Why do I think something is amiss? Because when he concludes that the whole proceeding at the federal level is not right, he says that the remedy to that is Najib's full acquittal of all charges, all 7 charges on him. Now that makes it extremely bizarre, because if the federal court is not the one that found Najib guilty in the first instance. Federal court only upheld the decision of the Court of Appeal and High Court. He also forgot that Court of Appeal upheld the judgment, the ruling of Justice Nazlan at High Court. And he also conveniently forget that High Court went through meticulously the facts of the case and the proceedings of the prosecution and defense in the first instance that found Najib guilty in the first place, that brought about the appeals up to the federal level, and the fact that even came to him, to his bench. So now, because he opines that Tengku Maimun and bench, federal court, did not conduct the proceeding properly, and it was not fair to Najib. If he opines that that's not right, then therefore the decision of that judge should be that there should be another federal court hearing where the accused is entitled to appoint his lawyer to present, to argue the case against the decision of the Court of Appeal to uphold Justice Nazlan's ruling. Means a retrial, a re-hearing at the federal level, because if only that is defective. He did not comment that the Court of Appeal finding was defective. He did not comment that the ruling of Justice Nazlan is defective. He is saying that Najib was not given the opportunity to be evaluated at the federal court level in a fair manner, and therefore grave injustice has been inflicted onto Najib. So therefore by the federal court. But he did not say there was grave injustice to Najib at the High Court. He did not say there was grave injustice to Najib at the Appeals Court. So therefore that thing holds. So how can, if something is wrong at the federal level, therefore it negates, it acts as though that it has overturned the decision of the Appeals Court? Why? Why must it go that way? Why can't it go the other way? Why can't you say, okay, because it's defective, therefore nothing, no change. The decision of the Court of Appeal holds. Why is it the other way around that favors Najib? So in other words, at the last part, if something was not right done to Najib, so whatever earlier that was done right is cancelled out, is it? So therefore, I find it very bizarre, this judge, this dissenting judge, and it brings to question, I become suspicious. What is his motive exactly? Is he really impartial and independent? I don't know. As a netizen, I begin to question, and I think a lot of people in the legal fraternity, and even the netizens who understands law and who follows the case, will begin to wonder, what is his motive exactly? And surely, he cannot be that incompetent. So, which is it now? Is he clearly incompetent, or he has an agenda? He has an agenda to also perhaps create a path for this thing to be continued by Najib's counsel, or also even prepare to bring this to the royals to get a royal pardon. So in other words, he's not closing the loop, and not does it. What he may not also realize, that by coming up with this finding, he is saying that if he says Najib should have been acquitted, he is implying that the High Court judge erred in his decision to convict Najib, because High Court judge says Najib should go to jail for 12 years and pay 210 million fine. He is also implying that the Court of Appeal judges, 3 judges who caught Najib an embarrassment and upholding the guilty verdict, also erred. In other words, he's implying that they should have overturned the decision. And he's saying that the federal court, comprising of the Chief Justice and the other 4 High Court judges, should have also overturned, at least listen to Najib's counsel, give him time to argue his case, and if they had given him time, they would also find that he should be freed and acquitted of all charges, and therefore the federal court then should also have overturned the decision of the Court of Appeal. This is by implication, this is what his ruling means. And even on his bench, he is the only dissenting judge. He is disagreeing with the other 4 charges. The other 4 federal court judges also, in his opinion, should also find it the way he finds it, that Najib should not have been charged or should not have been convicted in the first place. This is the effect it gives when he says Najib should have been acquitted of all wrongdoings, because there is a complete disconnect. If the federal court ruling, federal court procedure at the federal level, Tengku Maimun, is defective, how does that negate whatever convictions and whatever rulings of the lower courts that did? How is the failure of Tengku Maimun's bench, if so, serves as overturning of the decisions of the lower courts, which is the subject of the submission at the federal level? How? There is a complete disconnect that is not explained in his judgment. On that, I assert that his ruling is clearly flawed, and this will taint his reputation. It also taints the judiciary. It is regrettable, and I am inclined to believe that this could either stem from sheer incompetence or an ulterior agenda. Either way, it does not augur well for the judiciary, and it will be a permanent stain in our history of law.